So what is it that the Bruin decision, where the U.S. Supreme Court ruled in the case brought by the New York State Rifle and Pistol Association against a government official over a gun law in New York, the Supreme Court setting new precedent. Some saying, no, it's just going back to recognizing what the Second Amendment's all about, that, a well-regulated militia being necessary for the secure state. The right of the people to keep and bear arms shall not be infringed. Well, it's a legal issue that's in Illinois courts, both in state court and federal court. We shared a conversation we had with GPAC yesterday, the gun control advocacy group. They say a ruling by the Seventh Circuit Court of Appeals to not grant a preliminary injunction pending appeal of a Northern District case. But you also got a Southern District of Illinois federal case that's still being under advisement, and that's a pending decision which could actually possibly block the state law pending further action. So there's a lot going on here, but what's at the crux of the issues? Joining us now is the National Foundation of Gun Rights Director of Research Policy, Hannah Hill. Hannah, when I talked with GPAC, they said, hey, yeah, the Bruin decision brings about a new kind of standard of sorts, but they contend that governments still have the ability, under the understanding of text and tradition and history, that they've been able to ban unusual and dangerous weapons in the past, and they say AR-15s are just that. Where are they wrong?
So they're wrong because basically what Heller said is not dangerous or unusual weapons. What Heller said is dangerous and unusual weapons. So every weapon is by definition dangerous, or it's not any use as a weapon, right? So the caveat that the Supreme Court has created is that regulations may be upheld if they are affecting those dangerous and unusual weapons, things like tanks and bombers and things like that. So the AR-15 it has often been referred to as America's rifle, right? It's one of the most commonly used weapons out there. And according to Supreme Court precedent in Heller and in Bruin, the analysis stops there, full stop. You cannot categorically ban commonly used weapons, and nothing is more commonly used than the AR-15.
So with all of these different cases, not just in Illinois, we've got, at least 4 in state court. You got like 5, 6, 7, or 8 or so in federal court in Illinois. But Washington State just passed a ban on certain types of semi-automatic weapons. You've got a case in Maryland. You've got other kind of ancillary issues about, say, red flag laws and how this impacts that. Even down to, Hannah, the issue of whether or not users of cannabis are not allowed to have their Second Amendment rights for using cannabis. Here we are on 420 today. So what are we seeing here happen? What does this look like when it all starts meshing together out of all of the circuit courts and the appellate courts, and it gets to the U.S. Supreme Court? Are they going to have to be crystal clear on what they mean by text and tradition?
They're absolutely going to have to be crystal clear on that. And the thing about it was, when they issued the Bruin ruling last year, there were several other cases that were also pending. 2 were assault weapons bans, the one you mentioned out of Maryland, 1 out of California. There was a magazine ban out of California as well. The Supreme Court remanded all of these. They kicked it back to the lower courts and said, you saw what we said in Bruin, now go back and try it again because you got these wrong. Those are all still pending. And then we're seeing, like you said, so many other issues. One we've been watching is 18 to 20 gun bans, 18 to 20 purchase bans for individuals under the age of 21. There have been identical cases coming up in different parts of the country, one up in the 5th Circuit, one up in the 11th Circuit. Same issues, same arguments, wildly different rulings based on the judges and their willingness to apply the Bruin precedent. It's not a complicated precedent, right? It's not a complicated test. The more willing a judge is to say, okay, well, this is what the Supreme Court said we have to do. This is the facts. Let's just do it. It's a simple case at that point. That is what our case is here in the 7th Circuit. It's a simple case. It's a simple test. It's when people try to get around that test that things get really complicated really fast. So what you're seeing all over the country with all of these different issues and all of these different cases is an attempt on the part of the judiciary and on the part of leftist anti-gun lawyers from organizations like Everytown and such to see exactly how much they can get away with. And it's going to be up to the Supreme Court eventually to step in and say, no, we actually meant what we said in Bruin. You actually do have to follow the Second Amendment. You actually do have to apply the Bruin test. And we're not going to put up with any attempts to weasel your way around it.
We're talking with Hannah Hill. She's the Director of Research and Policy with the National Foundation for Gun Rights. Just some of the various groups that are out there. Of course, we've seen the federal firearms licensees of Illinois sue in the Southern District, but you've also got Law Weapons and Robert Bevis suing in the Northern District. That's now in the Seventh Circuit Court of Appeals, and they were originally challenging Naperville's gun ban as Law Weapons is in Naperville and being impacted by this. But what's interesting here is this dynamic in the Naperville case with Law Weapons is, say, the Southern District, Hannah, and we're going to do a little gameplay here, but say the Southern District says that the law is blocked, right, in the Southern District of Illinois. Bevis isn't part of that case. He's part of the Northern District cases in the Seventh Circuit. So while the Northern District judge said that Naperville's law is constitutional, the state's law is constitutional, if the Southern District says the state law is unconstitutional because that's what's being challenged down there, how would that impact a gun store like Law Weapons in Naperville?
Well, like you said, unfortunately, Law Weapons is in a very unique spot because they were fighting this policy before the state law ever passed. What you had, shortly after Bruin, you had the City Council of Naperville basically passing a ban on the sale of AR-15, right? And that's a ban that's going to put a local gun store like Law Weapons out of business, right? Simply because it's a disfavored business, although it is constitutionally protected. So it was our privilege to step in. I mean, Robert, he was out on the front lines. He was organizing the public support, mobilizing, on the political side, trying to get people to oppose the passage of this ban. And the city council insisted on doing it anyway, right in their faces. So it was our pleasure to step in. And initially, the lawsuit started out as a local challenge. We were suing to overturn this local Naperville ban. And then later on, when the state of Illinois passed a statewide ban, we were able to expand it because both will affect Law Weapons, right? So if the Naperville ordinance was struck down, but the state law was not, Robert's still not able to sell AR-15s, and vice versa. So we had to go after both in order to actually have a case.
But if we do have that Southern District judge say the state's law is unconstitutional, while the Northern District judge said the city's law is constitutional, what does Robert do in that case?
Unfortunately, Robert's up a creek without a paddle at that point, at least until we can get a Seventh Circuit preliminary injunction in the Northern District case. Because while the state law may be struck down by the Southern District, that's not going to be binding on Naperville. Naperville's local ordinance banning the sale of AR-15s is still standing. So it's one of those unique situations because Robert can only bring the lawsuit where in the court district where his business is located, and that's the Northern District Court. And we got one of the worst rulings there that we have ever seen. The court there simply ignored the Heller precedent. She did an in-run around the Bruin test, and turned it into a cost-benefit analysis on the Second Amendment, which is exactly what the Supreme Court said you may not do. And so, that's why we're appealing it. We appealed, and we asked for an injunction pending appeal. That's a preliminary injunction, if you will. They said no. They did not give us a reason on that, so we are hopeful that is not an indicator of how the preliminary injunction discussion will go. But unless the Seventh Circuit is willing to give us a preliminary injunction, Robert's business, which has been fighting this since before the state law was ever passed, will still not be able to sell AR-15s.
So is it safe to say, Hannah Hill with the National Foundation for Gun Rights, is it safe to say, and real quick here because we're out of time, but that the Naperville challenge here is important to also slap down local bans on certain types of weapons?
Absolutely. Because, it doesn't matter at the end of the day what level of government is taking away your rights. If you can't function as a business, you can't function and you're going to lose that business. And that is exactly what the Constitution is in place to prevent. So that's why we're fighting this case. That's why we're fighting for law weapons up in Naperville. And we're very excited to see what the Seventh Circuit's going to do.
Hannah Hill, National Foundation for Gun Rights. All the time we've got. Greatly appreciate taking with us today, and we'll talk again soon, all right?
All right. Thanks, Greg.
It is now 8:53.
It's time to apply at Culver's West on Wabash. We're hiring all positions, and did we mention